Welcome to Talk Testimonies. Today we're doing a deep dive into a really interesting Supreme Court case, Nielsen v. Preap. And it tackled this pretty fundamental question. When certain non-citizens with criminal records are released from jail, does the law requiring their mandatory immigration detention only apply if they're picked up right away?
Right. Or can immigration authorities detain them mandatorily weeks, months, or even years later?
Exactly. And the court, well, they ultimately landed on the side that the mandatory detention can happen basically at any point after their criminal release. It doesn't have to be immediate.
Which was a pretty significant ruling. So, let's unpack how they got there and what the arguments were.
Okay, so let's start with the basics. What was the core legal fight really about?
At its heart, it was all about how to read a specific part of the law, 8 U.S.C. section 926C. That's the bit that says certain non-citizens must be detained if they've committed particular crimes.
Okay. Mandatory detention.
Mandatory. No bond hearing usually allowed under this section. So the government side argued, look, once someone covered by this law is released from criminal custody, our duty to detain them kicks in.
Right then.
Well, the duty starts then. But they argued it doesn't matter when we actually make the immigration arrest. Could be the next day, could be years later. The mandate still holds.
And the other side, the non-citizens, the respondents.
They had a very different take. They argued, no, this mandatory detention, it's an exception to the usual rules. It only applies if you're taken into immigration custody right when you're released from criminal custody, or at least very, very shortly after.
So that phrase, when the alien is released, that was the real crux of it.
Absolutely. Everything kind of hinged on what when means in this context. Does it mean at the time of or just after?
Got it. So let's get into the arguments presented to the court. The government's lawyer, Mr. Tripp, what was his main line of reasoning?
So Mr. Tripp really hammered home the language of the statute, section 1226C2, which basically says you can't release these specific individuals on bond, period.
Okay.
He argued that the phrase, when the alien is released, pinpoints the moment the Secretary of Homeland Security gets this mandatory duty to take custody. He said, sure, it suggests some urgency.
But not necessarily immediacy.
Exactly. He framed it as an ongoing obligation. The duty to arrest doesn't just disappear if they don't grab the person right at the prison gates.
And how did the justices react to that? I imagine there were some probing questions.
Oh, definitely. Justice Sotomayor jumped right in, raising concerns about, well, what if there's a huge delay? Like someone gets released, lives in the community for years, maybe gets their life together, and then ICE shows up and says, okay, mandatory detention, no bond hearing for you. She pointed out a case where it was like 11 years later.
11 years? Wow.
Yeah. And her point was, if the government can just wait indefinitely, why does the law even have transition rules for implementing this? It kind of suggests Congress expected things to happen more quickly, maybe.
That makes sense. Did others pick up on that?
Justice Ginsburg did. She asked, basically, does the timing of the arrest make any difference to whether someone gets a bond hearing under this law? If you arrest them day 1 versus year 10, is it still mandatory detention either way?
And Tripp's answer?
He stuck to the government's guns. Yes, even with a long delay, the mandate applies. No bond hearing required under 1226C. Then Justice Gorsuch took it a step further, asking, does this obligation to arrest ever expire? Like if the government knows where someone is for years and doesn't act, is the duty still there?
And the answer was?
Still yes. A continuing obligation, according to Mr. Tripp. No statute of limitations on it, basically.
That's a pretty powerful position for the government. It really paints a picture of broad authority versus potentially individual liberty concerns.
For sure. And Justice Kagan explored the edges of this, asking if it applied even to people who weren't technically in criminal custody, but fit the categories, like maybe family members linked to terrorism activities described in the statute.
And Tripp said yes to that, too.
He did. Which again seemed to underline just how wide the government saw its mandatory detention power under this section.
Okay, so quite an expansive view. What about constitutional issues? Did those come up?
Big time. Justice Breyer really focused on this. He seemed quite troubled by the idea of mandatory detention without any chance for bail, especially, comparing it to the regular criminal system where even people accused of serious crimes usually get a bail hearing.
Right.
He brought up hypotheticals like, what if someone committed a relatively minor crime involving moral turpitude, say 50 years ago, served a short sentence, and now they're elderly and frail? Does this statute really mean they get locked up indefinitely without a hearing?
He was questioning the fundamental fairness.
Absolutely. He was pushing on whether that interpretation could even be constitutional.
How did Mr. Tripp counter that?
Well, first he argued the law isn't retroactive in that way, and maybe the 50-year-old minor offense wouldn't even meet the specific criteria, like the required sentence length for a crime involving moral turpitude.
Okay, trying to narrow the hypothetical.
Right. But Breyer kept pushing, drawing that parallel. If the government misses a deadline for bail in a criminal case, the person gets a hearing. Here, under the government's view, a delay could mean years go by. The person might be totally stable, no flight risk, no danger.
And still no hearing.
Still no hearing under 1226C. Breyer found that discrepancy problematic.
So what was Tripp's response to that core fairness argument?
He essentially argued better late than never. He said Congress specifically wrote this law, 1226C, to carve out these individuals from the normal bail considerations.
Like flight risk or danger to the community.
Exactly. He argued Congress decided that because of their specific criminal history, they'd forfeited the right to argue for release based on those factors. They were just subject to mandatory detention. And he pointed to the actual people in this case.
The named plaintiffs.
Yeah, Preap and others. He mentioned that some of them had actually committed more crimes after being released from their initial criminal custody, but before ICE picked them up.
Ah, raising the public safety angle.
Definitely trying to show that delaying the immigration detention could have real consequences.
Did any other justices jump in around this point?
Justice Alito wanted to clarify who exactly was in the group, the class, being represented. Was it only people arrested years later?
And it wasn't.
No. Mr. Tripp confirmed the class included anyone subject to 1226C who wasn't arrested by ICE immediately upon release from criminal custody. So it could be a delay of days, weeks, or years.
Okay. And did they have any idea how many people fell into the short delay versus long delay categories?
Justice Kagan asked exactly that. Some data, are we talking mostly short delays or lots of long ones? But Mr. Tripp said they didn't have specific numbers.
Lack of data there. So this idea of a reasonable time must have been debated then.
It was central. The respondents, the non-citizen side, argued strongly that if ICE doesn't act within a reasonable time, and they suggested that meant like the same day or maybe 48 hours, citing some older Board of Immigration Appeals cases.
Then what?
Then the mandatory detention under 1226C shouldn't apply. The person should fall back under the General Detention Statute, 1226A, where they can get a bond hearing.
And the government, did they concede any kind of time limit?
Nope. They stuck to their continuing obligation line. No specific deadline acknowledged.
Okay, let's switch gears then. What about the arguments from the other side? Mrs. Wang, representing the respondents, what was her core pitch?
Mrs. Wang really focused on statutory interpretation principles. She argued that the government's reading, where when released, just identifies the person but has no real timing element, makes that phrase basically useless, or surplusage in legal terms.
Meaning Congress wouldn't just throw words in for no reason?
Exactly. Every word should ideally have some meaning. She argued 1226C, the mandatory part, has to be read as a narrow exception to the general rule in 1226A, which does allow for bond hearings.
And that exception only kicks in when?
When the person is taken into custody when released. She stressed that the ordinary meaning of when implies closeness in time, immediacy.
So if ICE doesn't act quickly,
then the situation defaults back to 1226A, and the person gets their chance to argue for bond based on flight risk, danger, etc.
Did she highlight any problems with the government's view?
Oh, yeah. She pointed out the weird results it could lead to, like two people with identical criminal histories, both released on the same day. If IC picks one up immediately, they get mandatory detention. If IC waits a year to pick up the other.
They also get mandatory detention under the government's view.
Right. Ms. Wise Wang argued that makes no sense and treats similarly situated people differently just based on, essentially, when ICE gets around to arresting them.
Did she address the fact that Congress didn't explicitly write a deadline like within 48 hours?
She did. She argued that Congress knew in 1996, when they wrote this, that delays could happen. The fact they didn't put in a specific number, she suggested, meant they intended when released to carry its natural common sense meaning of immediacy or reasonable promptness related to the release event itself.
Did she have any data to back up the significance of delays?
She mentioned data from a related case that apparently showed the average delay between criminal release and IC pickup was something like 3 years.
3 years average. That's quite a gap.
It definitely underscores that these aren't just, hypothetical long delays. They happen.
Now, I remember Justice Gorsuch had a point about grammar.
Yeah, that was interesting. He questioned the structure. Does when the alien is released describe the alien, like the alien who is released, or does it modify the action of taking custody, like shall take custody when the alien is released?
Sort of. What part of the sentence is it connected to?
Exactly. Ms. Wang argued it modified the timing of the custody action, offering a hypothetical sentence structure to illustrate her point grammatically. It's a bit technical, but it ties back to whether when imposes a time condition.
And underpinning all this was the basic question of why we even have mandatory detention in the first place, right? As this exception.
Absolutely. What was Congress trying to achieve with this specific carve-out? That question is kind of looming over the whole debate.
Okay, so we've heard the back and forth. Remind us again how the Supreme Court actually ruled in the end.
The court sided with the government. The majority held that, yes, the mandatory detention under 1226C is triggered when the non-citizen is released from criminal custody, and that mandate remains in effect no matter how long it takes for ICE to actually take them into immigration custody.
So when released identifies the category of person, not the timing of the arrest.
That was the majority's interpretation. They felt the law's text didn't impose a specific time limit for the arrest itself to trigger the mandatory detention. The duty arises upon release and persists.
But there was dissent, right? Not everyone agreed.
No, definitely not. The dissenting justices argued strongly that when does imply time, suggesting detention should happen reasonably close to the release. They were very worried about the due process implications of the majority's reading.
The indefinite detention without hearings issue?
Precisely. They felt allowing mandatory detention potentially years down the road after someone might have reintegrated into the community raises serious constitutional questions.
And they also looked at the law's structure.
Yeah, the dissenters emphasized that 1226C looks like a narrow exception. Interpreting when released so broadly, they argued, kind of swallows the general rule of 1226A, which allows for bond hearings, undermining the structure Congress set up.
Okay, makes sense. So that brings us to our 10th chair segment. If we were sitting on the court, having heard all this, how would Talk Testimonies rule?
Right. Putting on our hypothetical robes.
Yeah.
We would actually rule differently. We'd affirm the Ninth Circuit's original decision.
Meaning you'd say mandatory detention only applies if the arrest is reasonably immediate.
That's right. We'd find that 1226C's mandatory detention applies only when the non-citizen is taken into immigration custody with, let's say, a reasonable degree of immediacy following their release from criminal custody.
And the reasoning behind that hypothetical ruling?
Well, it really comes down to trying to give meaning to all the words Congress used. That phrase, when the alien is released, seems crucial. If when doesn't have some temporal meaning, if it can just mean any time after, it feels like the word loses its punch, doesn't it? It becomes almost redundant.
The surplusage argument Ms. Wang made.
Exactly. And interpreting it the government's way leads to those strange outcomes we discussed, where someone released years ago, maybe totally reformed, faces the exact same consequence, no bond hearing, as someone picked up at the prison gate. That feels anomalous.
What about the due process concerns raised by Justice Breyer and the dissent?
That's a huge factor for us in the 10th chair, too. While we absolutely get that Congress wanted to prioritize detaining non-citizens with certain criminal records, letting that mandate stretch potentially years into the future raises serious fairness questions.
It shifts the focus, maybe.
Right. It becomes less about detaining someone immediately incident to their criminal release and more about detaining them based on a past status, potentially long after the fact, without the safety valve of a bond hearing. That indefinite detention possibility without a hearing is constitutionally uncomfortable.
So your hypothetical ruling wouldn't stop the government from detaining these individuals at all?
Oh, not at all. They could still detain them under the general provision, 1226A. The difference is, under 1226A, the person would get a bond hearing. They could argue they aren't a flight risk or a danger.
So it preserves the government's power to detain, but ensures a hearing if the arrest isn't prompt.
Precisely. It would align mandatory detention more closely with the actual event of release from criminal custody, which seems to be what when released points to. It puts a reasonable expectation on immigration authorities. If you want the benefit of this mandatory detention shortcut, you need to act relatively quickly.
Okay, so that's our take from the 10th chair.
A different path based on giving weight to when and considering those due process flags.
All right, that wraps up our deep dive into Nielsen v. Preap, a really complex case looking at the timing and scope of mandatory immigration detention.
We explored the government's arguments for an ongoing duty, the respondents' focus on immediacy, and the justices' quite pointed questions.
And in our 10th chair segment, we offered our view, emphasizing reading the statute to give effect to all its words and keeping those due process principles in mind.
And just a reminder, of course, everything we've discussed, especially our 10th chair opinion, is just commentary for discussion. It's not legal advice and definitely not the court's actual decision.
Absolutely. We hope this breakdown helps you think through the issues, and we encourage you to explore it further.
Thanks for joining us for this deep dive.